The CPI report, Child Protection in Iowa, is brought to you by Vocal Victims of Child Abuse Laws. You can watch our program all on Mediacom Channel 15 here in Greater Des Moines area and around the surrounding towns very close to Des Moines. You can see the program on Sundays at 1 o'clock p.m. Again, it's repeated on Wednesday at 9:30 p.m. Also, every other Thursday in Council Bluffs and Omaha on Cox Channel 23, you can watch the program at 4:30 p.m. That's every other Thursday in Omaha. You can email us at vocaliowa@mchsi.com. For the parents out there that would like to speak to us and get some one-on-one tips from our experience of over 20 years, actually, we're here to give free advice. My number is 515-276-3956. John's number is 515-282-2672. My name is Don Bergmeyer, and with me at the controls is my co-host,
John Harvey, and yes, for some reason we're not getting sound. Okay, there we're getting a little. I say welcome to the CPI report. That stands for Child Protection in Iowa. That is the sole purpose for which Vocal operates, and we have two major areas in which we work. One is to influence public policy as it relates to child abuse, and the other is to help directly with families who are having difficulties. Of course, since that is a one-on-one project, it's very time-consuming, but we're only too happy to give you assistance, and sometimes we know you're looking for lawyers and so forth. We are not lawyers. We'll be talking about the subject of law in a little bit here, and for some reason we're getting some static on your, I don't know why, but okay, yeah, that might work a little better.
you're talking to your guest at that point, John. Or is he a guest anymore?
No, that's not a guest. That's Terrance.
I thought I was a regular.
Regular.
That's right. So we're only too happy to have Terrance Walker.
I've elevated my status.
Right, you bet. Okay. We're going to be talking about how you operate with a lawyer if you choose to do so. If for some reason or another you found yourself in a position, and we'll give you some kind of an indication. Should I have a lawyer? Should I not have a lawyer? And some of the things that we should look out for. And the reason why that came up is because an individual called and said, we haven't heard that on your program. So we want to be as helpful as we possibly can. If one person has that as a need, there's probably many other families that have that need to know. So we'll try to follow through on that. There are a number of things that have come up in our Iowa legislature, and one of the criticisms that we have in watching legislation is, number one, it is created on a political basis. And of course, I suppose you would expect politicians to do something that is politically motivated rather than something that is helpful to children. And this last time around, they passed a piece of legislation called House File 619, and you can rough up your legislator all you want, because he can't get out by saying, "Oh, I didn't vote for it. Everyone else voted for it, but I certainly didn't vote for it," because every member of the Iowa General Assembly voted for House File 619.
How about the ones that forgot they voted for it yesterday?
You'll have to speak on that question, because I'm not for backing up one single bit. When they vote for it, they're responsible for that vote, and they're responsible to their constituency to explain why they want to spend $5.3 million on projects that have nothing to do with protecting children. And you can't tell me that DNA checking is to protect children. DNA only is helpful in detecting who the perpetrator might have been in a particular case. Well, you're not as much interested in protecting or finding the perpetrator as you are in getting that child back, or getting that child protected from harm in the first place. So why should we spend millions on that? It's one of the kinds of things that the prosecutor's office likes to do, and so they had that on their wish list. And as soon as a case came through that seemed as though it would alarm people, well, they just simply added that to their wish list and called that protection for children. There is one piece of legislation that went through, and I think we should probably pat our General Assemblyman on the back for, and that is one that tended to curb the use of meth by putting, and it seemed to be it seemed like a kind of stupid legislation when I first viewed it. But you have to look at sometimes you have to look at these legislative packages in retrospect and say, maybe that was a good law. But what it did was it put methamphetamine type of ingredients in cough syrup and everything else behind the window, so that someone had to sign. You'd have to sign for it even to get it out, and it was limited in quantity. So while it looked like kind of a silly bill to pass, it has had an amazing effect on driving down homemade meth in Iowa, except for in Davenport, where they can drive across the river and get whatever they want in Illinois, because they don't have those rules over there. So while we're only too happy to critique laws that are bad ones, I'd like to stop off once in a while and say, hey, you guys must have been doing some thinking when you passed that meth ingredient bill that made it difficult for meth makers to use cough syrup to create something that was not good for the body and not good for the family. Well, that's what's been happening in the legislature. All too often, we create legislation out of a crisis situation. And so it is in our General Assembly. House File 619 was born out of a crisis type of situation. Everybody was alarmed. And so that's why you get 100% participation in some of these bills that are not well thought out. In one case, go ahead, Terrance.
I was going to say that's what I call legislative lynch mob mentality.
Yeah.
Because that's what they all did. As soon as this big thing hit the news, they were in uproar, and of course, who's going to vote against it? They're going to say, well, you didn't vote to save the kids. And next election, they'll be out of office. So, I think it'd be a good policy if they weren't able to resort to these quick measures for political gain.
Quick fixes.
Yeah, quick fixes. Legislation should have. I know there's some instances in which urgency is demanded, but not in the instance in which it's purely, for the most part, for political gain.
A lot of these initiatives are along that line. You've heard a lot about getting your kids fingerprinted as a measure to protect the children. Pray tell, how does it protect your child to have a copy of his fingerprints down at the police station? Fingerprints on file do not protect children. They only assist you in identifying the body. Now, of what value is it to identify the body? Wouldn't it be better to turn your sights on protecting the child by some other initiative, not these silly initiatives that are brought up by the Attorney General's office, Tom Miller's office, when he brews up all this stuff? I call it Miller Brewing. Um, the it's a shame that we spend our resources on something like this. Right now, we're spending $5.3 million to implement a law that is to implement this law that has to do with DNA testing. It has a whole bunch of things that have nothing to do with protecting children directly. So, and that price tag will go up to $12 million, and your legislator voted for it. In one case, they're saying that we know that the problems arise when boyfriends shack up with women who have children. Therefore, we won't permit boyfriends to shack up with girls who have children. That is, those who are on the Megan registry. Well, they've already run into some snags on that part of House File 619, and they'll continue to run into snags. And I think the bills of the $5.3 million is only the beginning of the cost when you have to stop to realize that the bill also includes a provision whereby sex offenders, so-called sex offenders, which can be burglary or anything else. It doesn't have to have anything to do with sex, and it doesn't have to do necessarily with children. And we're going to bar them from living within 200 feet of a school or a daycare center.
It's actually 2,000 feet.
Did I say 200?
Yeah.
Yeah, it's 2,000 feet. A good portion of a mile away from the boundaries of the property, not just the building itself, but it's the boundaries of the property, 2,000 feet. And to impose that as an unfunded mandate on every police unit in the state of Iowa, including the Highway Patrol and the county mounties and the whole works. What we have done is we've taken a scare tactic and turned it into some real folly, a very expensive folly when we make up silly rules. How does it protect a child sitting at in his math class to know that the person who is a sex offender has to live 2,000 feet away from the school? He may be the guy that's out front mowing the grass. He may be a contractor's assistant who's working on the electrical system in the building or trying to beef up the air conditioning. How does it help to know that he lives more than 2,000 feet away from the building? Well, you see, they don't bother to incorporate logic or common sense with these laws. It's really a shame. And the real shame is when they collect a bunch of problem areas like the theft of a child, kidnapping of a child in Florida, and they listen to what the father says, and then they go to another location, listen to what the parents say in that case, and then they boil that down and put it into a federal, into the Congress, and call it the Children's Safety Act that targets sex offenders. This was recently in the halls of our U.S. Congress. Child sex offenders would be subject to stringent monitoring requirements and face new mandatory penalties under a House-passed bill that expanded to include protections of gays and lesbians under federal hate crime. They're going to take care of the gays and lesbians, but they're sure going to slam dunk anyone who is known to be a sex offender. The House voted 371 to 52 Wednesday in favor of the Children's Safety Act, which, among its many provisions, creates a national website for child sex offenders and stipulates that sex felons face up to 20 years in prison for failing to comply with registration requirements. Have you ever heard of a law that requires that you sign your name? And if you don't sign your name at within the given time frame that you're required to, that failure could wind you up in prison for 20 years. Now, something is wrong with the common sense that I think, should be a prerequisite to any congressional act. But in this case, it doesn't. Unexpectedly, the House voted 223 to 199 in favor of an amendment by John Conyers of Democrat of Michigan that expands the current hate crime law to include some crimes involving sexual orientation, gender, and disability. Under current law, the federal crimes government assists local and state authorities prosecuting limited types of crimes based on the victim's race, religion, or ethical background. Now, you see, when you get these omnibus bills and everybody can come in and pile on, they're saying that that you should vote, your legislator should vote for this bill because it goes to keep children safe. But according to John Conyers, we ought to keep homosexuals safe from certain kinds of actions. Joe Salmonese, president of the Human Rights Campaign, the nation's largest gay rights group, said it was an incredibly historic vote that could give momentum to similar actions in the Senate. The new sex offender bill, which also requires felony offenders to register for life and authorizes the death penalty for sex crimes resulting in the killing of a child, responds to the House Judiciary Committee. James Sensenbrenner, responds to what House Judiciary Committee Chairman James Sensenbrenner, Republican of Wisconsin, said was a national crisis in child offenses. He said that some of the 550,000 convicted sex offenders in the nation, the whereabouts 100,000 is unknown. So of these 500,000 offenders, 20% of them you can't find them. Now, do you suppose that the offenses could come from that 20%? Really, how effective is the law that does 80% of its work? So Mark Foley of Florida said, we track library books better than we do sexual predators. They probably do. Sensenbrenner said the legislation would get favorable treatment in the Senate and expected to be signed into law by the end of the year. So we're opening up a new can of worms here. A very broad terminology, and it's uniform throughout the nation. And millions and millions and millions of dollars are being spent on this at a time when President Bush is talking about cutting back spending. The Children's Safety Act will certainly increase it. Not only at the federal level, but there are many, many unfunded mandate implications in this, which says that local officials will have to be standing by to implement all this at their expense, or we should say at our expense. Sensenbrenner said the legislation would get that favorable treatment. The White House, in a statement, expressed support, saying that even though sex crimes against children have declined, and they have significantly, in recent years. More needs to be done. Yeah, when the statistics are falling, we really need to get excited, because they could fall to nothing, and then we'd have all this bureaucracy simply out there wasting money.
And some people would go out of business.
That's right. Um, see really how stupid some of these things are. It noted that the legislation codified the online National Sex Offenders Public Registry that the Justice Department launched earlier this year. The legislation brings together parts of numerous proposals to protect children from sex offenders. Sections of the bill are named after victims' cases, see, which is another silly thing, to make these like memorials after these unfortunate situations like Jessica Lunsford, a 9-year-old from Florida. Among the criticisms of the bill were that it could further ostracize people who have paid their debt to society for their crimes and are trying to live normal lives. Out-of-jail offenders facing harassment or unable to get jobs, and it may go underground and not bother to. People may go underground and not bother to register again. It'd be a good idea to change your name, wouldn't it? Change and disassociate yourself from your social security number. So what if you have 100,000 of those people who are underground? Do they still pose a threat? Well, no one really knows. And all this federal legislation is not doing too much good. So we're going to have all kinds of, let's see, there's an amendment to eliminate several mandatory minimum sentences, including one creating a minimum penalty of 5 years and a maximum of 20 years for offenders who fail to comply with the registration requirements. It was defeated 316 to 106. Yeah, they don't want to get rid of the penalties, but the penalties are very costly when you realize that to put someone in a cage, for 20 years at $70,000 a year runs up a bill. And it runs up a bill that we don't need.
Against the taxpayers.
Yeah, that's right.
A pretty big bill. Federal court. federal.
Yeah, it'd be a federal violation.
Yeah.
Yeah, and many of those are 100% terms. That if you're sentenced to 75 months, that means you serve 75 months. There's no parole or probation or anything. Among the provisions of the bill, it creates a national website and requires states to notify federal government of any changes to a sex offender's registration information. In Washington State, they even make them get new pictures if they shave. So if they had a beard before and they shave their beard off, they have to submit a new picture, because you certainly wouldn't want somebody registered who changes their appearance from time to time. And I suspicion that's probably in the fine print of this bill too. States are required to notify each other when a sex offender moves from one state to another. Now, how are they going to do that? It requires each state, they can't even keep track of your baggage on the airplane. How are they going to keep track of all these details of people moving around day to day? They're related to their, let's see, it creates a national website and requires the states to notify the federal government of any changes to a sex offender's registration information. States are required to notify each other when a sex offender moves from one state to another. It requires each state to maintain a statewide internet site to include such information as an offender's address, picture, vehicle, and facts about his conviction. It broadens the category of sex offenders to include any felony or misdemeanor sex offenses against minors. In Iowa, they don't care what the offense is. Even if it's not a sex offense, it still goes on the Megan registry, which is downright stupid. Yeah, that's right.
Is that what you're saying? It could be a drug
bet.
crime?
So any kind of a crime goes on the Megan registry if it's a crime against a child. It broadens the category of sex offenders to include any felony, misdemeanor, sex offense against minors. The category of crimes covered by this bill is extended to include juvenile sex offenses and possession of child pornography. Felony sex offenders will have to register for life, and misdemeanor sex offenders for 20 years. It creates a verification program under which the sex offender must report by mail every 30 days. Now that really is a stupid requirement, particularly since if you don't register on any 30-day period, you could be sent to prison for 20 years. It requires criminal background checks of prospective foster care families. It ensures mandatory minimum sentences for violent crimes against children, ranging from death or life imprisonment for a child when a child is killed, or 30 years in prison for crimes involving kidnapping, maiming, or aggravated sexual abuse. It expands the use of DNA evidence to solve sex crimes. So there you have it. A lot longer than what I anticipated going through, but it gives you some kind of an idea of what is happening not only in the General Assembly of Iowa, but what is happening around the nation to waste taxpayers' funds on a misguided program saying that they are protecting children. Can we have any great confidence in such a thing as this? We're going to go back to that topic of lawyers. And to start off that discussion, we're going to turn to Terrance, who's done a little research on what we should do if we have a lawyer, or when we should have a lawyer. Terrance Walker.
Well, he put a big burden on me. I didn't really know I was going to be called the expert on this. Yeah, my name is Terrance Walker, the judge of the judges here in the state of Iowa. Chief judge of the judges, because nobody else can do it better for you. You can call me honorable. I'll accept that title of nobility, although the Constitution forbids title of nobilities, and we have these judges that go around calling themselves the honorable this, the honorable that, justice this, justice that, and that is, so to speak, a title of nobility. But that's a different subject for a different day. On the subject of lawyers, when to have one, when not to have one, well, I guess it would start with the issue of money. If you have enough money, then you should get a lawyer. If you don't have enough money, then maybe you shouldn't. But the problem is that the title that's on the United States Supreme Court building in Washington, equal justice, or equal justice under the law?
Correct.
Equal justice under the law. That is a facade here in the society, because we all know, anybody that's ever been to court, has ever witnessed any court proceedings involving people that are with money, people that are wealthy, and people that are not wealthy, you know that that is a facade. Equal justice under the law. You only get equal justice under the law. The whole idea is a facade, first off, but you only get justice under the law, I should say, if you have a little bit of money. If you don't have a little bit of money, then you're going to be getting a court-appointed attorney, or if you're very lucky, a legal aid representative, or if you're very, very, very lucky, a pro bono attorney willing to help you out of the kindness of his heart, or of the kindness of that law firm's heart, I should say. But yeah, equal justice under the law. So how do you go about, I guess we should go about tackling the issue of whether or not you should have a lawyer if you're without money, or if you're not disposed of great wealth. For one, if you're in a criminal case, that you'd probably be forced to go to get a court-appointed attorney through the public defender's office, or one that is on the list of court-appointed attorneys for that courthouse or that district. If you're in a civil case, such as a divorce or some sort of lawsuit involving your dogs or something to that nature, you may be able to get, like I said, a legal aid attorney, or you might be able to get, if you're lucky enough, a pro bono attorney to help you out in that situation. Um, I guess the question that John, what you initially posed to me when we were determining what to actually discuss during this segment was how do you decide whether to keep an attorney? Is that what it was? How you decide how to best use an attorney?
How best to use an attorney, even if you're court appointed to one?
Well, you
Does
know,
does the attorney simply take over and make all the decisions for you at this point?
uh, well, you know, I could go funny on that. You know how to use attorney, but I won't.
Okay.
Uh, one thing I will say, I will ask you, what do you call 25 attorneys buried up to their chins in cement?
A good start.
Not enough cement.
Okay.
But all jokes aside, you know, I've got lawyers in the family, so you know that's not to disparage all lawyers. There are some very good attorneys out there. I guess a good start is if you have a personal injury claim and you know some people, start asking around. If you have a personal injury case that's coming up or that you want to file, who's a good personal injury lawyer? And chances are, you ask enough people, you'll get an answer. If you're a criminal, or if you're in a criminal case and you're innocent, uh, you know, the lawyer's creed, a man is innocent till proven broke. I guess that kind of, and again, like I said, the lawyer's creed, a man is innocent till proven broke. But if you're already broke, then chances are you're going to be found guilty unless you have a very, very good attorney, and you're very, very lucky to have that good attorney. So if you're basically not disposed of the legal knowledge to represent yourself, um, and you're facing a lot of years, then you know you might want to ask around. Well, who's the best court-appointed attorney? Who's the best attorney that's with the public defender's office? And you might just try to haggle your way. I know it might take a great deal of frustration and discussion with people and arguing back and forth with people, but you might be able to get the best court-appointed attorney just by, you know, asking other criminals who's the best one, and then haggling your way till you get that one. A lot of judges do not like to allow you to change attorneys, and you know they don't technically they don't have to, unless you can cite some sort of conflict with the attorney that you have. If you have a conflict over the way you should be represented, or if you have a major conflict of interest, some sort of way with that attorney, you may be able to haggle your way and get the judge to give you the lawyer of choosing. They don't have to do that, but they do have to remove the attorney if you do have a very, very deep rift with the attorney that you're with. So, you know, I would definitely stress that if your lawyer's not doing all that he can, that you feel that can be done to represent your best interests, haggle with him, file some stuff in the court if you have to get him removed, file a motion to remove this attorney, and lay out some of the differences that you have, and you know, make sure that that's put on the record. Don't let them just easily dismiss your stuff. Make sure you demand a hearing. Make sure you're heard. Make sure you testify as to the allegations that you're making against the attorney. What do you have to say, Don?
I have found from experience and watched and came to the conclusion the one of the big holdups on not being able to get rid of an attorney that's doing you wrong is because you fail to state the right words on paper. A well-worded short document goes a long ways to remove an attorney. and then you've got the option of representing yourself or getting a new attorney to replace you, which the court loves to have you have an attorney. Terrance?
And further in furtherance of that, if you have a little bit of legal knowledge, or if you don't, hopefully you have somebody that you know that has a little bit of legal knowledge. Cite some sort of cases that say that something to the effect that you have a conflict with this attorney, and therefore you should be able to you should use that as a basis, that case, the legal case, as a basis for the attorney's removal.
One thing that I've heard is a phrase that is a kind of a catchphrase, but it simply says that the attorney is not zealously guarding my legal interests. And then if you can show how that lawyer is not zealously guarding, for an example, if you called him 15 times and he's returned no phone calls, you've written to him 4 times, he's written no notes back, you've emailed him 58 times, he's made no effort to respond to your emails, then you can say that that attorney is not zealously guarding your interests. And I think it also
he's not being an advocate either.
No, no. So that, and of course, the key word for the whole thing is called
ineffective assistance of counsel in a criminal setting.
Correct.
I guess you could sort of argue that in the civil setting as well, but it doesn't play a constitutional role as such as it does in a criminal setting.
Have you seen situations where the counsel is just not listening at all to his client and is taking actions that the client would prefer not to take?
Well, I've read about cases where counsel has even fell asleep during cases. So, I mean, that's
a good thing, isn't it?
That's another instance. Yeah, there's another instance. And
if the judge also goes to sleep.
They've actually, I think it was in Texas. Matter of fact, the Texas lady that was just executed last week had that attorney, one of the attorneys that was found to have fallen asleep during a felony murder case, which is indeed crazy. But
Crazy.
Yeah, it's insane. But another thing that you could tackle along these lines is if they're not advocating a potential winning issue. If you have a winning issue, they're not putting it forward. Definitely lay that before the courts. Make sure they have a hearing on it. Demand a hearing. So you want your due process rights to have a hearing on your motion to remove the attorney that you have, and they'll have a hearing for you, and you can testify to what you feel are your issues that are left out that you feel would win your case if the attorney is not putting forth.
One of the things that we've advised people, because a lot of them will come in with complaints about their attorney, and we say, rather than bringing those complaints to us, here's what we'd like for you to do. Would you keep a log of the times that you've attempted to contact your lawyer? Would you write to your lawyer and tell your lawyer what it is that you want to accomplish as a result of his efforts on your behalf? And tell the lawyer the information that you believe would be important to have in your case. If the lawyer does not comply overall with your wishes, of course you can have the lawyer replaced. But you can use that log as a piece of evidence before the judge to show that you have done a competent job of being a client, that you've done your work as a client, and you've notified the judge what it is that you want, and the kinds of things that you think would satisfy you with respect to that. Because the lawyer is not your boss, you are the chief executive officer of your defense team. and you're just like the quarterback or the chief executive officer of a corporation. Your lawyer is there for for your use as a professional person who is skilled not only at the law at the bar, but is skilled in research. And so, if you ask him to dig up cases that are important to prove certain points, he should do that for you. Now, he's not your puppy, and so you have to treat him with a degree of respect and dignity. But he is not your boss, and you shouldn't be able to come to the end of your case and say, "Well, my lawyer didn't do this or my lawyer didn't do that," because I would ask you then, did you instruct him precisely what you wanted to do in writing? Then also, if he doesn't behave in court as you believe that he should, that is, he doesn't put forth the kinds of things that you think are necessary for your defense, then it would be wise for you to simply stand up right in the hearing and wait for the judge to recognize you. The judge may listen to you, but the judge may simply tell you, sit down. But this is one way you can get the attention of the court and say, I need the attention of the court in order to enter information. I've attempted to do this through my counsel. My counsel is reluctant to do it. So I want this information placed in the record. So you can place in documents into the record. You can place in conversation that you have into the record at this point. Go to your attorney first. Don't undermine him by thinking up something tricky that you as a tricky way around him. Tell him what it is that you want into the record, and then if he doesn't perform, you show him how you would prefer that he perform at that point. Don?
20 years ago, I came into the system, and at that point in time, I experienced the feeling that a parent does not have any rights when it comes to the legal system, being in court. Since that time, I have talked to many parents, and they all have that same feeling. Parents get brainwashed into believing you have no rights, and yet the Iowa Code is full of rights for parents. Your court-appointed attorney is not going to point out rights to you. He wants to control the whole thing. So I'm telling you, parents, you do have rights, and you've got to exert them. And if you want to get rid of the attorney, you need to state it on paper that he is no longer your attorney. Terrance?
Yep. On a different note, I don't know if you guys were done with this topic. I was going to move on to the
Go right ahead.
next issue here. As we've been talking, there's been there's one book that I'd like to mention here. I found online. I know you were wanting to research this issue a little bit here. There's a book that I found online, the Law and Order in America, one blank of a bad smell. It's been edited by our editing department. This book purports to, I haven't read it, but it purports to tell you how to get a good attorney. I just wanted to put that on you can get this online.
We want to get real close
well,
on this attorney.
It's not a really clear picture here.
What's he got in his hand?
He's got money, but
dollar sign there, money falling all out of his pockets. Look at that.
But on the next issue here, I don't want to get too far away. I don't know too much about that book. Maybe good, maybe not. But I just thought I would put that out there. That's the only book I could find online that purported to help you find a good attorney.
Law and Order in America.
But definitely do not worry about going to these referral services. I've tried them a number of times. They do not work.
I have too.
Ask them for an attorney that can help me on my child support issue. they'll recommend me to a criminal law attorney. I'll ask them for a personal injury attorney. They'll recommend me to a bankruptcy attorney. And I'm like, what are these guys here for if they can't get it right? So, it's totally bungled set of procedures that they have, I guess they go by, but it doesn't make a whole lot of sense.
But because the person is an attorney doesn't mean that he is proficient in every aspect of the law.
Exactly.
You're saying that it's a good idea to get an expert in the area in which you were being pursued in court.
It's always the best route, I would say. That's why I say if you're a criminal, go to other criminals and find out who's the best criminal attorney.
Okay.
If you got in a personal injury, go to somebody that's been injured and ask them who's the best in that field or who they had represent them, how good they did, and then you can judge for yourself.
If you're a liar, go to the best liar out there, huh?
Well, you might be going to another lawyer.
Oh, really?
But anyway, on a different note, on the burner for the topic of the courts here in America has been the issue of the nomination of a one Judge John Roberts. You've got it. I think you got his picture there. He's been up for nomination, and he's actually had a hearing. They've had a hearing the past week, matter of fact, on this whole issue of him being approved to the bench of the United States Supreme Court. We've got one justice retiring, another one actually died. So we've got two vacancies, one to be filled by this man, John Roberts.
He's borrowing two of my names, my first name and my second name.
Yeah.
If he takes the third one, that'll be Harvey's rest of the story.
I don't think he can live up to that third name, though.
Okay.
I think you have far greater potential than he can be as a justice. And before I get on that, I'll name some of his accolades here. I've always said that accolades and scholarly accomplishments do not mean nothing in the way of judging equal justice under the law, because that phrase means a lot more than scholarly accolades. There's been a lot more people that have been far judicious or have had far greater sense of justice that have not had these scholarly accolades. So to me, it means nothing. But anyway, on to his scholarly accolades. He graduated from Harvard Law School. He clerked for Judge Henry Friendly and William Rehnquist, the former Chief Justice who just passed away. He used to be employed as an associate counsel to President Reagan and Deputy Solicitor General for George Bush I, or George H.W. Bush. And then he was also a partner at Hogan and Hartson. And he's now a United States Court of Appeals Justice for the D.C. Circuit. And on this little cheat sheet I found online, a couple of his notable opinions that were discussed here the past week on civil rights and liberties. For a unanimous panel, he denied the weak civil rights claims of a 12-year-old girl who was arrested and handcuffed in Washington, D.C. metro station for eating a French fry. Roberts noted that no one is very happy about the events that led to this litigation and that the Metro Authority had changed the policy that led to her arrest. And then I guess they thereby denied her claim. And then he also denied a friend of, in a private practice, he wrote a friend of the court brief arguing that Congress had failed to justify a DOT affirmative action program. That was in 2001. The previous case was in 2004. And then he also, in 1980, under the Reagan administration, opposed a congressional effort to make it easier for minorities to successfully argue that their votes had been diluted under the Voting Rights Act. And then he's got a number of different opinions on separation of church and state. He's got a friend of court brief. And they've got a number of different issues here, which I really don't think I have a whole lot of time to go into. I thought the civil rights and liberty issues that he had supported the voting rights thing, and then the habeas corpus issue, which in one case in 2004, he joined a unanimous opinion denying the claim of a prisoner who argued that by tightening the parole rules in the middle of his sentence, the government subjected him to a unconstitutional after-the-fact punishment, or in other words, ex post facto law. And the panel reversed this decision after the Supreme Court ruling directly contradicted it. So in his rulings, which haven't surfaced until really lately, the guy really doesn't have a record, so to speak, a public record on his personal views, but, you know, through his alignment of his with the Reagan and Bush administrations and some of his views, he seems to appear to be for a limitation on civil individual rights and liberties. In a recent opinion, which was released just this summer, he even co-authored an opinion on the D.C. Circuit Court, which basically said that this was Hamden versus Rumsfeld, in which a guy was trying to determine his rights under the Geneva Convention. Hamden, I guess, was alleged to be a former driver for Bin Laden, he's actually housed at Guantanamo Bay. He was basically trying to get a determination of a prisoner of war under the Geneva Convention. Well, unfortunately, D.C. Circuit Court, along with Judge Roberts, didn't want to give him that distinction because that might have implicated that he was to be given a hearing in front of a military tribunal. The D.C. Circuit, under a principle of deference to the President as Commander-in-Chief, basically stated that are basically held in concordance with I'm sorry, I've lost my space here on these notes here. They basically said that the tribunal lacked authority to determine whether, as such, a member or affiliate fighting in Afghanistan, whether he was entitled to the Geneva Convention. And on this issue, the tribunal accepted the President's determination that Al-Qaeda categorically does not qualify. So basically, he didn't even get a hearing as to whether or not Al-Qaeda or someone who was associated with that organization is entitled to a prisoner of war status, which, you know, short-sightedly, you might say nothing wrong with that opinion. You know, he's a terrorist, and, you know, he posed a grave threat to the United States. But let me pose it this way. Now, in the long-term things, long-term scheme of things, if one can assert this position, and as the district court observed, I'm citing the district court, which the D.C. Circuit Court had reversed, and I'll quote them: "The government has asserted a position starkly different from the positions and behavior of the United States in previous conflicts, one that can only weaken the United States' own ability to demand application of the Geneva Conventions to Americans captured during armed conflicts abroad." So in the long term, this may in fact not only cause us as American citizens to suffer as well, because who's to say that if we go abroad as American citizens, someone can just label us as the imperialist network, and, you know, we'll have no determination. Let's say they have a president over there that just labeled us. Well, in the long term, this could negatively impact us. Using the same line of reasoning, they may withhold an American citizen in another country and withhold their rights and put them in basically a concentration camp for an indefinite period and then deny them a hearing. And that could be you, that could be me, it could be any one of us. So, you know, this is a guy that obviously, you know, in my frame of mind, he's willing to yield whatever decision for the authority and not in favor of individual rights. And as such, you know, I know there's been a big fuss about him being a nice guy, but that being said, there are a lot of people who appear to be a nice guy. The BTK serial killer was said to have been a nice guy, and so was Jack the Ripper. This is not to say that John Roberts is a serial killer, but just to point to the fact that a nice guy should not be the sole quality by which we judge a judge, nor should their scholarly or career accomplishments. And what I felt was missing from the nomination hearing and the dialogue thereon was an honest discussion of the judge's views and the consequential effects of them. It's not simply enough to say that, as Roberts, that his memo positions in the past under the Reagan and Bush administrations represented the views of the administration or that administration of whom he was employed. This is a judge who chose to align himself with those administrations and admittedly held some of their views. It is suspect that a huge amount of Roberts' past memos were not available for public scrutiny. And this is supposed to be a free and open society. And we entrust a huge amount of responsibility in a Supreme Court justice. And to limit such a discussion or to limit his career record as a public servant to a discussion of memos which have selectively been chosen is scandalous at best. Then to give him a list of cases and questions to prepare for in advance, such as some of the senators had done, is doubly scandalous. This man is using as an excuse not to answer his questions on his views the future possibility of having to recuse from a case. Yet in the Hamden case, he recently put himself in apparent conflict when he should have probably recused when he met with Bush while deciding the challenge to Bush's power under the War Powers Act. In that case, Roberts held that prisoners of war can be held indefinitely without being declared prisoner of war. But what we failed to have discussed is how is this a war power? So, you know, all in all, this is basically an ivory tower candidate who is hardly a class act, and the whole nomination hearing, in my mind, was a facade. So, you know, they didn't talk about the true discussion on what judicial accountability. They didn't talk about how judges ravaged through pro se claims or mismanaged cases or anything that I feel was important. But I'll wrap it up with that. I had some lengthy discussion on that.
Okay. Well, thank you for that presentation on lawyers and on our chief law enforcement officer, who will be heading the Iowa Supreme Court or the U.S. Supreme Court. The only difference between a taxman and a taxidermist is that a taxidermist leaves the skin. So says Mark Twain. We'll see you next